Hello, I'm Doug Terrell. I'm the coordinator of the Hoosier Hills Prescribed Burn Association. I'd like to take a little bit of time to discuss Indiana House Enrolled Act 1557 entitled Prescribed Burning. The act cleared the legislature on April 17th and is currently awaiting Governor Braun's signature. Assuming he does sign the law, it will become effective July the 1st. All good laws have a number of definitions. A certified prescribed burn manager is a person who has successfully completed the Division of Forestry's prescribed burn manager training program. Landowner agent, a person who has permission from a landowner to use prescribed burning on the landowner's property. A prescribed burn is the planned application of fire to a naturally occurring vegetative fuel to accomplish one or more land management objectives. Those objectives include a forestry operation, a vegetative fuel reduction, a silviculture treatment, a wildlife habitat improvement, the management of a grassland, a forest, a woodland, a savanna, or other plant community. A prescribed burn plan is a written plan in the format approved by the Division of Forestry that establishes the conditions and methods for prescribed burning. That format has not yet been defined. Section 5 discusses landowner rights. A landowner has the right to conduct prescribed burning on the landowner's property. However, they do not automatically get the benefits of this law. So basically, there were no changes to landowners' rights. Section 6 is the requirements for protection. Before the burn, you must obtain written consent from the property's landowner. You must also have a written prescribed burn plan prepared and approved by a certified prescribed burn manager. You must notify the local fire department and county dispatcher at least 24 hours before the prescribed burn. Here's my comments on Section 6. This is not part of the law. Notifying both the fire department and dispatch is redundant, but that's the way the law is written. I'm commenting here with almost 40 years of experience on a volunteer fire department, so I have some experience and understanding of how this is going to work. The 24-hour requirement is too far in advance, but again, that's the way the law was written. My advice here is comply with the letter of the law, but in addition, I would suggest strongly to call dispatch when the fire is set. This might be as the fire is being set, 15, 30 minutes before. Hello, dispatch. This is landowner. I'm setting, as I told you yesterday or the day before, I'm setting a prescribed burn at this location. Here's the responding fire department. I'll call you when it's out. Thank you. Also keep in mind that the law says the nearest department, but the nearest department may not be the one that actually responds to your fire. And that gets into jurisdiction lines. You may be on the far edge of the township and think the neighboring department is closer to me, but they're not the one who's going to get the call. I think that's a technical problem with the law, but it's workable. Section 6, requirements for the protection during the burn. You must have at least one certified prescribed burn manager on site of the prescribed burn. Make particular note of that requirement. You must also have a completed copy of the prescribed burn plan in the person's possession. Now, whether that means in their back pocket or laying on the seat of the truck a quarter mile away, I would tend to think probably needs to be in the back pocket. It says possession. Section 7 is what the law is really all about. This is the protection that you're going to get if you comply with Section 6. A certified prescribed burn manager who conducts the prescribed burning in accordance with Section 6 is immune from civil liability for harm caused by the prescribed burn or smoke produced by that burn. However, there are exceptions. The immunity described above does not apply if the harm was the result of the certified prescribed burn manager's negligence. When I approached the Indiana Prescribed Fire Council, and all of their work in the initial draft said gross negligence here, but there was a lobbying group that came in suits and ties and says, that doesn't protect the neighbor nearly enough. We want to be able to take it to court, and we would like to strike gross negligence and insert simple negligence. We are still much better off than we were without a law, but it would have been nice to have gross negligence. Essentially, gross negligence is going to get it thrown out of court. It's nearly impossible to prove. Also, if it's willful and wanton misconduct. There again, those are legal terms that the lawyers want to take to court and iron out there. Section 7C talks about landowners. The landowner or their agent get the same protection if they comply with Section 6. But recall I mentioned the point about having a certified prescribed burn manager on site. So a landowner does not get the protection. They can conduct the burn, but they don't get the protection unless they have a burn manager or have had the burn manager training. Exemptions. The prescribed burn is exempt from any prohibition or on burning vegetation issued by a county or municipality, including a local disaster emergency declaration. Now, I'm going to comment here. If it's a burn ban in place, more than likely, the conditions are out of prescription. An emergency declaration, though, could include something like a tornado. You planned to burn, there was a tornado the day before, the burn conditions are still there. The county EMA says we have a burn ban on because of the tornado. There you would be exempt. But most of the burn bans that are being very common in southern Indiana are probably going to put you out of prescription anyway. Section 9 talks about nuisance. Also another good point. Prescribed burning and the smoke produced by prescribed burning do not constitute a nuisance. That's the wording of the law. My comment is, if the fire department responds, nuisance is going to be one of those things they use to say, yeah, you're doing okay, but we're going to put your fire out. They should have been notified. Smoke should have been addressed in the burn plan. Another point I will bring up, you need to have someone on site at the burn. If the fire department shows up and has no one there, they're going to put the fire out, I can promise you. Section 10 is damage limits, also a very good point here. Damages for injuries or losses as the result of a prescribed burn are limited to actual damages. If this gets to court, there's not going to be a large punitive damage set. It's only actual damages. Section 11 talks about authority. The Division of Forestry shall administer the prescribed burn certification program and standards for completing a prescribed burn plan. That pretty much ends the technical discussion of the law. I'm going to insert some comments here and what I have some understanding of. Proposed required training to get to be a certified prescribed burn manager is probably going to include the 4 NWCG online courses. That's what we've talked about in some other Prescribed Burn Association meetings. That's going to get you the classroom work of the firefighter type 2. That's published as about 40 hours of online training. In practicality, you can probably do it in a lot less than that, maybe in the 16 to 20 hour range. Indiana DNR currently has, and this is going to be a requirement as I understand, a prescribed burning for managers class. It's typically a 2-day class taught up at the fire headquarters at Martinsville, and they hold that class usually the first week in December. Hopefully they make it a little easier to get into and they open up the number of seats. Time will tell on that. The third requirement will be for the person who has completed the other two requirements to participate and be lead on either 3 or 6 live burns. Now there's going to be an endorsement, as I understand at this time, and this is still fluid, for either grassland or woodland. So if you're only burning grassland, you participate in 3 live burns, your certification is good for grassland. If you want to do woodland, you participate in 3 woodland burns, your endorsement is good for woodland. If you want to do both, you participate in 6 burns. This is a healthy amount of training. I think this is a good thing. There were some discussions while this was working its way to make it very simple, maybe an 8-hour course, and when it finally came out, they said, we want this to basically be a wildland firefighter who has some serious knowledge and training if you're going to get this liability protection. In my personal opinion, I think this is very practical. As far as the Hoosier Hills Prescribed Burn Association, I'm going to put a commercial in here. Please follow us on Facebook. Reach out if you're interested in becoming a member. I can pretty much tell you that the PBA will have 1 or more certified prescribed burn managers as members. That's the point we're working for. You may contact me directly at doug@HoosierHillsPBA.org. Thank you for your time. If you have any questions, please feel free to ask.